Hi, this is Lisa DeMonte from mylegal.com. Today is Tuesday, March 23rd, and we're here for the third and final day at the Georgetown University Law Center Law Firm Evolution Conference, Brave New World or Business as Usual. My guest this afternoon is Tim Scrantom from Georgetown Capital Management. Tim, welcome. We're delighted to have you here this afternoon.
It's a great conference.
Thank you. We're all having a lot of fun and learning an awful lot, that's for sure. Tim, tell us about Georgetown. When was it formed and what's your involvement?
Georgetown is a fund, private equity fund, listed on the London Stock Exchange. My company, Georgetown Capital Management, is the exclusive manager of that fund, and we designed basically the operation of the fund and brought about the launch in December 2007. Since then, we've been very actively in business both in the UK and in the United States. We've invested in about 23 different case matters, some through law firms, some through claim holders. And we feel like we've been enormously successful, having come into a marketplace that didn't really understand what this product was, but we found that the market acceptance is just fantastic.
So you're an American lawyer yourself, an English
Yes.
barrister. So I'm sure you see a lot of differences between what's going on in the UK, Australia, certainly Germany, I think, as compared to what's happening and what's accepted in the United States. Tell us a little bit about those differences and how you think it's going to impact the way things will change in the future.
Very different cultures. It is near and dear to my heart that that there is this U.S.-UK connection. As a lawyer in both countries, I can say that it was the phenomenon in England that really captured my attention. They passed legislation in 2007 that institutionalized this phenomenon of investing in claims. They call it third-party litigation funding. And I looked at that phenomenon. I said, why not in the United States as well? So the British have been very pioneering as a culture in this area, which is a little counterintuitive, I suppose, when you think about them as being stodgy and very traditional. But in this area, they've been very cutting edge. The systems, though, are very different. The U.S. system and the British systems are very different. So the way I think the markets are going to absorb outside capital coming in the U.S. and the U.K. Are going to be quite different. They're going to follow very different timelines, I think, and so forth. Australia is yet a distinct market as well. They were probably the first country to look at this phenomenon of buying and selling claims and investing in claims. Passed legislation about 10 years ago that allows this. So the British and the Commonwealth generally have been very much at the leading edge of this phenomenon, but I think it's clear that the U.S. is the biggest market for it.
So it seems like the wave is coming from the east to the west as opposed to what's normally happened is it going from the west to the east.
That is true, and it is, as I said, sort of counterintuitive that the British would be innovative in a field like law. But it's driven by some of their own circumstances there. The fact that principally they don't have contingent fees in cases. And although they probably will in the relatively near future, they don't at this time. And so, as I like to tell my British colleagues, you may have passed the first legislation to allow so-called third-party funding in cases, but we invented the idea of claim transfer with contingent fees and lawyers taking effectively interest in cases. So it's something that they institutionalized first, but I think we more or less invented.
Interesting. I think you mentioned, Tim, that the UK adopted these new, are they guidelines, rules in 2007?
It was actual legislation signed by the Queen.
So 2007, and here we are 2010, and it seems to have been embraced and is being utilized quite well. if we see some additional expansion of third-party funding in the U.S., do you think it's going to be embraced that quickly? Will change happen that quickly? Or because of some of the issues that we're dealing with in the U.S., such as contingency fees and such, and ethical concerns, do you think that that movement will be slower?
No, I don't think it'll be slower, and there are a variety of reasons for that. One reason I think the uptake in the United States has actually been quicker is because this market understands transferring risk in litigation. The only difference is for the last 100 years, there's been only one buyer, really, and that is a lawyer who could take a case on a contingent fee basis. So what the public is seeing and what the law markets here in the States are seeing is that if you have an alternative to that, if you've got a true capital market alternative to selling part of your case to your lawyer, does that make sense? Mm-hmm. And the resounding answer is yes. Now, the rather interesting thing that we've discovered when we first started into business was we thought that we might be stepping on the toes of law firms if we were effectively coming in with a solution or an alternative to the way they were financing cases through contingent fees. But what we've found is, although law firms like the potential reward out of a contingent fee arrangement, they, in the end, don't want to take as much risk as often they have to. So the idea of taking a reasonable amount of risk is very attractive to the lawyers as well. So we found a bit of an anomaly, and that is that the law firms out there are at once our sort of biggest competitors, but our biggest advocates as well. So
that's a good place to be, for
yeah,
sure.
Yeah.
One last question. Tony Seabuck obviously presented a fascinating paper on third-party litigation funding. Were you surprised by his findings? Did you think that they were accurate? Not accurate, but were you surprised by the findings?
I was surprised at how lucid they were. I'm obviously very familiar with the concepts he was dealing with. I know Tony very well. We've had a number of conversations about this field. But what he was able to do, I think, albeit in a rather academic fashion, was to define what I might call the sort of stigma surrounding the idea of third-party funding, capital coming into law markets, or whatever the phenomenon is. He was able to sort of trace that empirically and expose the fact that there really isn't a rational basis in today's world for these restrictions. And I just think he did a terrific job with that.
It was certainly well received.
Yeah.
Tim, thank you so much for taking the time to join us this afternoon. We wish you well.
Thank you very much.
Thank you.
Thanks.